all the roads, of course, lead to Rome, but this one will not be leading to Rome. We are, the topic is European constitutions, religion and state, and the status of religious minorities. I think that when one discusses the contemporary European constitutional order as regards religion and state, I think the dominant image in the academic and normative discourse is that a contemporary European democratic constitution and hence a contemporary European liberal democratic state are secular and neutral. Neutrality is a very key word in the discourse, even more than secularity itself. Neutrality is usually understood to mean that the state and its constitution as its basic document, therefore, a state regards itself as neutral between different religions, different ideologies, different worldviews, including religious worldviews, and at least arguably different cultures. This is much more problematic if you think about language and things like that, but at least when it comes to religion and ideology and worldview, the strongly prevalent interpretation is that the natural result of the principle that is really universally accepted, the principle of equality, since all citizens are equal, therefore the state, a liberal state, should not prefer the worldview of one group of citizens over the worldview of any other group of citizens. If it does, it somehow infringes on the principle of equality. It cannot treat citizens equally and groups of citizens if their worldviews, their cultures, their religions are not regarded equally by the state. So equality is then is interpreted in such a way that it necessitates state neutrality in matters of religion. This is what is often said and usually not even argued but taken for granted. Whereas when one reads the actual constitutional documents of contemporary European democracies, one immediately sees that in quite a few cases there is no neutrality at all in what concerns religion. There is always a great emphasis on equality. Equal rights to all citizens regardless of, among other things, religion. There is a long list of things regardless of which every citizen is equal. The equality of all citizens regardless of religion. And, of course, religious freedom, freedom of worship, freedom of religion, freedom from religion, as regards all religions. These are really, in fact, the basic principles of contemporary European constitution, and nothing that I am now going to quote derogates from that, because I'm going to quote the non-neutral passages, but every constitution that I quote also very prominently includes passages and articles that promise civic equality to all and religious freedom to all. So the state is neutral in this sense, that it does not discriminate between citizens on grounds of religion. But as to the attitude of the state to religion itself, mainly on the symbolic level, but not always. And this does have some impact on the question of minorities, but as to what the constitution of a democratic state says about religion itself, it is quite often non-neutral. Although there are certainly quite, I would say most constitutions are, but a substantial number clearly and substantially deviates from this model. Now, the discourse, the judicial discourse, which is of course highly important, it is a discourse which actually translates general principles to the language of actual norms. What the European Court of Human Rights and the various European constitutional and other courts, high courts, say on this, this discourse combines in a very peculiar way elements of neutrality, the term often appears in them, but also acknowledging the actual non-neutrality, the term is not used, but what is acknowledged is the predominant role of Christianity in the cultures of those states, because this is what those constitutions say. And so how you combine secularism and neutrality with some level of acknowledgement, public acknowledgement, of the dominant element of Christianity in the national culture, this is a big question, and this is not always comfortably reconciled. And when people try to reconcile the two, I think that is most problematic. When sometimes people claim that, I would put it crudely, that Christianity should be preferred because it is more neutral. It is more secular and more neutral than other religions. You have that, actually, quite a lot. And I think this is where it becomes problematic. Now I will start quoting I will quote some documents. There is nothing like a primary source. The Constitution of Ireland, of the Irish Republic, it used, by the way, the Constitution of the Irish Republic used to include a statement that the Catholic Church is the predominant religion of the Irish people, but they have dropped it. They have removed it. So there is the Constitution is no longer Catholic in any sense, but it is Christian and Trinitarian. It starts with the following, the preamble: "In the name of the most holy Trinity, from whom is all authority and to whom as our final end, all actions both of men and states must be referred. We, the people of Ireland, humbly acknowledging all our obligation to our divine Lord Jesus Christ, who sustained our fathers through centuries of trial, gratefully remembering their heroic and unremitting struggle to regain the rightful independence of our nation. For 800 years, the Irish people have been struggling to regain the independence of the nation. They have not heard, those who wrote it, that nations did not exist for 800 years ago. In the case, this is what they write in their constitution. Then they say, of course, that there is total equality of all citizens regardless of religion. Now, the constitution of the Greek Republic, that was formulated in the 70s after the restoration of democracy and removal of the right-wing dictatorship. So it's a modern, it's a relatively modern constitution. Is not content with referring to Trinity, but it says in the name of the holy and consubstantial and indivisible Trinity. There are all kinds of Trinities. The Greek Republic has an official opinion on the nature of the Trinity. The Fifth Constitutional Assembly of Greece votes, and etc. And then the article on church and state says the following: the prevailing religion in Greece is that of the Eastern Orthodox Church of Christ. The Orthodox Church of Greece, acknowledging our Lord Jesus Christ as its head, is inseparably united in doctrine with the great Church of Christ in Constantinople, and with every other Church of Christ in the same doctrine, observing unwaveringly as they do the holy apostolic and synodic canons and sacred traditions, and so and so. And then they also give details about the various ecclesiastical instruments by which the church is ruled. And then they say the text of the Holy Scripture is maintained unaltered. Official translation of the text into any other form of language without prior sanction of the Autocephalous Church of Greece and the Great Church of Christ in Constantinople is prohibited. Now, I don't know how they enforce this prohibition. I assume that it's merely a symbolic statement, but it is a very strong symbolic statement. By the way, the church in Constantinople, of course, is ruled. The Patriarch of Constantinople is, of course, a Turkish citizen of the Turkish Republic. And by the way, the city of Constantinople, I think, now has another name, a different name. But in this document, it is called Constantinople. Now, in Norway, which is a Nordic, far away, peaceful, and indisputably more so than Greece, I would say, indisputably a liberal democracy, and actually, as other Scandinavian countries, a very secular state. There is no necessary connection between what the constitutional document says and what goes on the ground. The Norwegian constitution is much more religious than the Polish one, and we know exactly which country is much more religious. But the Norwegian constitution, that until recently included very archaic and very far-reaching statements on the status of the Lutheran Church as the church of state, they have changed it 2 years ago. So they brought it up to 2 years ago. The Norwegian parliament decided to amend the constitution and to formulate exactly the relations between the Lutheran Church and Norway as they are today, not as they were written 100 years ago. And having been amended in favor of watering down the connection, the term religion of state no longer appears, but what appears in today's constitution, the up-to-date constitution, is that all inhabitants of the realm they start have the right to free exercise of their religion. The Norwegian Church, the Evangelical Lutheran Church, remains Norway's church, no longer official, and supported as such by the state. Specific provisions on the organization thereof are laid down by law. So the law of the state regulates the internal organization of the church. All religion and religious groups are supported equally. So this is balanced by equality. Another symbolic link between the church and state is provided by Article 4, which also was in the old constitution. The king at all times professes the evangelical Lutheran religion. Moreover, an entirely new article has been added, enumerating Norwegian national values. I quote, "The basis of our values remains our Christian and humanist inheritance. The Constitution is to ensure democracy, the rule of law, and human rights." So the Christian inheritance is put into a comfortably liberal surrounding, but it is still our Christian inheritance. Now the Greek constitution that I quoted also includes an article saying that the President of the Republic has to swear by the Holy Trinity when he takes office. And so in both countries, the head of state must belong to the dominant religion. I would say that the Norwegian constitution and also the Danish one that says the Lutheran Church is an established religion and the king belongs to the established religion. So in Iceland, although there's no king, and in another way in Finland, no longer in Sweden. Sweden used to have the Lutheran Church as an official church. That was removed several years ago. So these articles on when they say the king has to become the dominant religion, you could argue that there is no violation of civic equality because, after all, the office of king is not a modern office that obeys any democratic principles. There is no civil right to be a king. There is no equal access to this office. It's a symbolic thing. So with some charity, I would say maybe with a modicum of Christian charity, you could say that there is no violation of civic equality. But there is certainly a total negation of neutrality. The thing, it is purely symbolic, and of course the whole power of the king is purely symbolic. But what is symbolized by this article, exactly the opposite of we treat all religions equally. Okay, that is precisely the reason why it's there. Whereas I think President of the Republic should not be. I think it's wrong that an elected official, even a symbolic head of state, should be officially confined to a specific religion. This I'm afraid, is a violation of civic. As I said, in Scandinavian countries, famously you have the same situation in England, but I think really we can now say it's really on its way out. I think that the officially established status of the Church of England is really now has become an anachronism. It is still on the statute books, it is still the law, the Queen still appoints bishops, no longer really by decision, but still there are some aspects, but we know that Prince Charles has made it known that he wants to be sworn, if and when he wants to be not defender of the faith, but a defender of faith. He wants to remove the article. Well, in Latin, of course, it could be either way, so it's a perfectly legitimate translation of what the Pope conferred on Henry VIII in the good old times. So I think in England this is on its way out, although still there, but in other countries, in Scandinavian countries and in Greece, it is still a real thing. And then you have other interesting articles that do not speak explicitly of an official church or an established church, but the Constitution of Bulgaria, which is a very interesting country because it does have a large Muslim, Turkish, national and religious minority. The Bulgarian constitution, which is not a veteran democracy, but its constitution has been vetted by European experts. All those new democracies write their constitution under the watchful eye of the kosher inspectors of the European Union because they want them to be admitted into the European Union, the Council of Europe. So that has been approved. The constitution of Bulgaria says that the church religious institutions shall be separate from the state. So there is explicit separation of religion and state. But then it says, Eastern Orthodox Christianity is considered the traditional religion in the Republic of Bulgaria. And in Armenia, which has also been examined, whose constitution has always been examined and approved, given a nihil obstat by the European Union, the Armenian constitution includes a much stronger statement: the church shall be separate from the state in the Republic of Armenia. So that's the first, that's a secular state. The Republic of Armenia recognizes the exclusive mission of the Armenian Apostolic Holy Church as a national church in the spiritual life, development, and the national culture and preservation of the national identity of the people of Armenia. So that's a very strong statement made several years ago by the Armenian parliament, and there is a Georgian constitution which is not as strong but similar. The Polish constitution among the new democracies is very interesting because, of course, everybody knows what the true situation is in Poland compared with Denmark. But precisely because of this, because the Catholic Church in Poland is so strong, and secular parties in the Constituent Assembly that formulated the Polish constitution, the new one, was strong enough and were apprehensive enough to insist on watering down any reference to the predominant religion, the Polish constitution, exceptionally, is an explicitly agnostic document. It says, "We, the Polish nation, both those who believe in God as the source of truth, justice, good, and beauty, as well as those not sharing such faith, but respecting these universal values as arising from other sources." So we, the Polish nation, some of them believe in God and some of them don't. That's a very exceptional. God is often, God generally without a specific religion is very often present. And when he is not present, I have never seen an agnostic statement in the Constitution. But then they also say, beholding to our ancestors for their labors, their struggles for independence achieved at great sacrifice, for our culture rooted in the Christian heritage of the nation and in universal human rights. So the culture of the Polish nation, both of those who believe in God and those who explicitly say that they do not, is rooted in the Christian heritage of the nation that is accepted by everyone. This is the Polish compromise, an interesting one. So when you have those general statements, what does it mean when it comes to really controversial issues of religion and state, including issues that I start with the Christianity and then I move to Islam? So I will now analyze two concrete issues. One is the crosses and the crucifixes, the legal status of the cross and of the crucifix in the public sphere, and then the vexed issue of Muslim headscarves, which is, of course, now discussed in Europe, and it really goes directly to the issue of religious freedom and civic equality, at least according to some interpretation of the Muslim community. How far it is really allowed to practice what at least many Muslims regard as part of the religion, although it is also disputed how obligatory it is, but it's certainly part of the Muslim tradition. And it should be, of course, we should recall that these issues are also relevant to the Jewish communities, and there are some real issues that have arisen lately with the circumcision, the demand to ban it, and of course ritual slaughter. Those two issues that unite in a way these two communities despite their other differences. So on the question of cross, of course we know that there are crosses on quite a number of European national flags, including the Scandinavian countries and Greece, and including the 3 crosses on the British flag, although most people don't notice this fact, but these are actually 3 crosses on the Union Jack. And all the states that incorporate the Union Jack, like Australia and New Zealand and some provinces of Canada. So there are plenty of crosses. There are crosses on emblems, on coats of arms. But in Italy, which is a secular state, because since 84, before that, the Catholic Church was an official religion, a remnant from Mussolini's Concordat. But in 84, that was removed by agreement between church and state, And Italy, the constitution says freedom of religion. The Italian constitutional court says secularism is part of the constitutional order of the Italian Republic. Secularism does not appear in the constitution, but it does appear in the language of this constitutional court. So it is officially a secular republic. Now, in this secular republic, there is still a law according to which in every classroom of every public school in the Republic of Italy, there has to be a crucifix, not a cross, but a crucifix. In every classroom, that is now, there are different, the only other European country in which there is such a law is Austria. Also in Austria, there is a law that says, I don't know if any, but in schools, there are crucifixes. In Germany, the Constitutional Court in Germany ruled that it's unconstitutional for some of German states, Bavaria, of course, was a clear example, to have such a law. The court said you cannot, it's against freedom of religion to have such a law, but they said, or rather, the Bavarian parliament interpreted this decision as saying that a crucifix can exist in those classrooms, but it should be removed if one pupil, or that means, of course, the parents of a single pupil object. If there is anyone who objects, they have to remove it. If no one objects, it's okay. Now, some years ago, I was in Munich, and my hosts were telling me this story, and they were strongly against it. And I asked them, but what's the problem? If it is removed upon request, what's the problem? They say, told me, in Munich, there may not be a problem. But think of a kid, a poor kid in a school in some village in Bavaria or small town in Bavaria, whose parents come to school and say, remove the crucifix. It is, in practice, not at all easy to do such a thing. So it's a real dilemma. But in Italy, in the Italian Republic, it's a law. Actually a decree from the time of Mussolini, but there were previous decrees to the same effect. And then a parent, not a Muslim, but an agnostic, went to court and challenged this, claiming that it's against the secular nature of the state and religious freedom as guaranteed by the Italian constitution, as interpreted by the Supreme Court. The Italian administrative court in Veneto rejected the petition. It went to the Council of State, which is the highest administrative court. It was rejected. Then she, I think, the parent, Lauzi, the Lauzi case, famous case, went to the European Court of Human Rights and got a judgment from a chamber of the court against Italy, ordering the Italian Republic to remove the cross from classrooms because it is a violation of neutrality or of religious freedom. There was a huge outcry. The Italians appealed to the grand chamber of the court, the full court, and 3 years ago, the grand chamber of the European Court of Human Rights has ruled in favor of the Italian Republic, therefore ruling that it is not against all those European liberal principles for a state to have a law that obliges every classroom in every public school to display crucifix. Now, the judgment of the court, of course, is extremely interesting, but what I would like to quote in extenso is not the judgment of the court, but the judgment of the European Administrative Court that rejected the petition. And I think this is, gives you an example of how you can combine official commitment to secularism with a crucifix as a legal obligation. You might think that if a state, unlike Greece, declares it, or Norway, declares itself to be secular, then there is no room for such a thing. Well, the Italian Administrative Court says the following: at this stage, the court must observe, although it is aware that it is setting out along a rough and in places slippery path, but they nevertheless say it, that Christianity and its older brother Judaism, at least since Moses and certainly in the Talmudic interpretation, have placed tolerance towards others and protection of human dignity at the center of their faith. I was very glad to read that. Singularly, Christianity, for example, through the well-known and often misunderstood render unto Caesar the things that are Caesar's and so on, They don't pronounce the other part. Through its strong emphasis placed on love for one's neighbor. This is what the Administrative Court in Veneto says. Through the strong emphasis placed on one's love for one's neighbor, and even more through the explicit predominance given to charity of a faith itself. This is the true nature of Christianity. That charity is privileged over faith itself. Contains in substance those ideas of tolerance, equality, and liberty which form the basis of the modern secular state and of the Italian state in particular. Looking beyond appearances makes it possible to discern a thread linking the Christian revolution of 2,000 years ago to the affirmation in Europe of the right to liberty of the person and to key elements of the Enlightenment, even though that movement, historically speaking, strongly opposed religion, namely the liberty and freedom of every person, declaration of the rights of man, and ultimately the modern secular state. So the Christian revolution started the modern secular state. And so on and so forth. I don't have time to, but it's a remarkable document. Moreover, with the benefit of hindsight, it is easy to identify in the constant central core of Christian faith, despite the Inquisition, despite anti-Semitism, and despite the Crusades. They know their history. And they are self-critical properly. The principles of human dignity, tolerance, and freedom, including religious freedom, and therefore, in the last analysis, the foundations of the secular state. Now, all that is very fine, so I might ask, so that means that Christianity is a wonderful religion, but how do you justify putting a crucifix in a classroom? Why should it be an obligation? It can therefore be contended that in the present day social reality, the crucifix should be regarded not only as a symbol of a historical and cultural development, and therefore of the identity of our people, so the crucifix is a national symbol of the Italian national identity, but also as a symbol of a value system, liberty, equality, human dignity, and religious toleration. The crucifix is the symbol of all that, and according also of the secular nature of the state. It must be emphasized that the symbol of a crucifix, thus understood, the symbol of all good things, now possesses, through its references to the values of tolerance, a particular scope in consideration of the fact that at present Italian state schools are attended by numerous pupils from outside the European Union, to whom it is relatively important to transmit the principles of openness to diversity and the refusal of any form of fundamentalism, whether religious or secular, which permeate our system. Therefore, it is particularly important to have a crucifix in the schools, precisely because there are a lot of people who may not have been blessed by having a heritage that includes all those things. And then they say, in fact, religious symbols in general imply a logical exclusion mechanism. General. As the point of departure of any religious faith is precisely the belief in a superior entity, which is why its adherents, the faithful, see themselves by definition and by conviction as part of the truth. Consequently, inevitably, the attitude of the believer faced with someone who does not believe and who is therefore implicitly opposed to the supreme being is an attitude of exclusion. One might think that this is a good justification for real neutrality. And then they say, the logical mechanism of exclusion of the unbeliever is inherent in any religious conviction, even if those concerned are not aware of it, the sole exception being Christianity. Now, the older brother is forgotten now. It is the sole exception is Christianity, where it is properly understood, which of course it has not always been and still is not always the case, not even thanks to those who call themselves Christian. In Christianity, even faith in God is secondary in relation to charity, meaning respect for the other fellow human beings. It follows that the rejection of a non-Christian by a Christian implies a radical negation of Christianity itself, a substantive abjuration. But that is not true of other religious faiths, for which such an attitude amounts at most to the infringement of an important precept. The cross as a symbol of Christianity can therefore not exclude anyone without denying itself. Therefore, there is no problem of exclusion, there is no problem of lack of neutrality, and the secularism is enforced by the symbol of the crucifix, and this is how it should be regarded by anyone. That is not unproblematic. I think it would have been much less offensive to any to anyone who might be offended. It is a question whether one should be offended with things like that, but if anyone is offended, I think it would have been much better to say, well, this is our national symbol, this is a symbol of our culture, live with it. We are not forcing on you anything, and that's it. rather than saying this is the symbol of tolerance and openness, and it is the only, actually, it is the symbol of the religion, which is the only religion which is fully committed to openness and tolerance. That is a problem. But this is what the Italian court says. The higher court says it the same thing, but in a less striking way. The European court quotes this, does not react to any of it. The European court says, well, for us, crucifixion is religious. Whatever else it is a religious symbol. But it does not, therefore, become illegal, because they say it does not introduce indoctrination. They do refer to the principle of neutrality. They say the Italian state is obligated to religious neutrality, referring to the European Convention of Human Rights, Article 9, that speaks about the freedom of religion, does not mention neutrality at all. The term neutrality does not appear in the convention. The court says you are obligated to neutrality, but then by stating that there is neutrality, it finds itself forced to interpret neutrality in a problematic way. So why is a crucifix not a violation of neutrality, which it obviously is, of course? Because there is no indoctrination. When there is no indoctrination in the curriculum, there is an atmosphere of free debate, and therefore, they interpret neutrality as a duty not just not to coerce, but not to have indoctrination. That's a very reasonable interpretation of equality. Civic equality should mean that a person is not coerced by the state against one's religion, and also is not indoctrinated against one's religion, as Jews in former times were in Rome. They were forced to hear sermons. They were not coerced, but they were indoctrinated. So you can say that in a free, modern, free, liberal democracy, the state should not indoctrinate. But to say that a crucifix in a 10 minutes, okay, in a public school, it does not infringe the principle of neutrality, I think is disingenuous interpretation of the principle of neutrality. Now, there is another famous ruling that the European Court approved the Turkish law that outlawed the welfare party that was accused by I would say, the previous Turkish government of seeking a Sharia state, a religious state. And the court ruled that it is democracy has a right to defend itself. That's a very known principle. But it ruled that not only they say not only that a Sharia-based state is against democracy, which is maybe taken as a rather obvious statement, that Sharia, the Muslim Sharia itself, as a system of divine law that does not change, that cannot be changed, is against democracy. Now, I think every Israeli appreciates the difference between saying that a halachic state is against democracy, a halacha-based state is against democracy, and saying that the Jewish religious law is against democracy. Many will say that, but they may not necessarily be happy if a foreign court will say such a thing. This is what the European Court of Human Rights has said, but in a more far-reaching way. There is, of course, the issue of headscarves. Now, France has banned them altogether in public schools. Among civil servants, it has been banned for all religious symbols have always been banned. But in Switzerland, banned it only among teachers. A teacher, a Muslim woman, of course, wearing a headscarf, went all the way to the federal court in Switzerland, then to the European Court of Human Rights, challenging this ban on her right, her freedom of religion, to express her identity in this way. And the court approved sanctioned the Swiss ban and said that there is no violation of her rights. That her rights were limited in an appropriate way. And the problematic part is not the part where they say that in Switzerland the law says that there is a denominational neutrality of the schools, and therefore a headscarf of a teacher is a violation of the denominational neutrality. That in itself is a reasonable statement, although one might ask, how is a crucifix not a violation of denominational neutrality, which is proclaimed by the Italian judicial system? And the headscarf worn by a person, by one teacher, is. But you could say, well, different states have a different way of dealing with that. You can say this is reasonable. But they went on to say that one of the reasons why the headscarf may be banned is that it is a symbol which is hard to reconcile with the principle of gender equality and tolerance. So that is a reflection on the, not on the secularity of the state, but on the character of a particular traditional religious symbol. And that is, I think, a problematic statement, to say that the headscarf itself is difficult to, they don't say it's against, difficult to reconcile. Because the logic of this is to say, if something is difficult to reconcile, then you go one step further, say it contradicts. If headscarf, a Muslim headscarf, contradicts gender equality and human dignity and tolerance, then the logical question is, why don't you ban it altogether? It's not just a permission to ban. It is something that should not be tolerated. Now, no European, of course, nobody dreams of forcing any European state to ban it, and then it could be banned not only in school. But that is at least the radical secularist language used on such occasions at least opens the possibility for much radical solutions. I think we should think of it when we hear about attempts to ban the circumcision, or because it is, certainly it says, certain things in traditional religions are against what we consider to be liberal principles, and we do not allow them in the private sphere either, not just in the... Finally, my final remark is that while France has gone for banning the headscarf in a very far-reaching way, but at least the French do respect the principle of secularism and neutrality, and therefore, although everybody knows why the ban is introduced because of the Muslim veil, they also ban impartially all religious symbols, the cross, which is much less relevant, the big cross is much, much less relevant, and also the kippas, of course, of the Jews, so there is no discrimination with different religions. A different story is unfolding in Germany, and a very problematic one. There is I don't have time to read it, but there is a report by Human Rights Watch which is called Discrimination in the Name of Neutrality. And the story that they tell is the following. The German Constitutional Court has ruled that a state has a right to ban. It cannot be done on a federal level, but every land in Germany has a right to legislate on education, so they are entitled to ban. And half of the German states have banned the Muslim veil in schools and in some other civil service position, and half haven't. So it's different rules apply in different lender. But among those who have banned the Muslim headscarf in Germany, more than half of those who did it include also an exception for symbols that reflect the Western Christian tradition of the Federal German Republic, which in Bavaria means, and when I was in Munich, they told me, they are now trying to devise, to find a formula that will ban the Muslim headscarf, but not the nun's habit, because nuns in Bavaria do teach religion in state schools. It is not obligatory, you don't have to take those lessons. But these lessons of religion are given by nuns, and nuns are dressed like nuns. So in Bavaria and in some other German states, there is a general ban on religious symbols. But then Christian, and by the way, the kippas also, the Germans don't want to mess with the kippa, so the kippa is accepted as part of the Western Christian tradition. I assume it is the Westernism, not the Christian. So it is part of the Western tradition, but the symbols of the Western Christian tradition are exempt from a ban on religious symbols in public schools. This has not been totally endorsed, but is, I think, in the process of being examined by the courts, and one wonders what the final conclusion will be. I finish.